What are the duties of a director in a company? Hello and welcome back to the channel. In today's episode, we're going to dive into the question of what are the duties of a director in a company as prescribed by the Companies Act of Sri Lanka. Let's get started. The law relating to the duties of a director in a company in Sri Lanka is laid down by the Companies Act No. 7 of 2007, which supersedes the 1982 Companies Act. Now, before we talk about the duties of a director, we first need to understand who a director of a company is. A director of a company, simply put, is someone who will manage the affairs of the company on behalf of its shareholders. A company will usually have more than one director, who will be called the board of directors. However, it is possible to have a company with only one director. Section 201 of the Companies Act of 2007 states that a company must have at least one director, except public companies, which must have at least two directors. Further, Section 202 says that a person appointed as a director must not be disqualified from being so appointed. Section 202 subsection 2 provides a list of factors which may disqualify a director, which include not being 18 years of age, not being of sound mind, etc. Now, a person appointed as a director of a company will be subjected to several duties as per the sections of the Act. The first duty imposed on a director of a company is in Section 187 of the Act, which imposes a duty to act in good faith of the company. This section emphasizes the fundamental obligation of directors to prioritize the well-being of the company and its stakeholders in their decision-making process. So basically what this means is a director must always put the best interest of the company above all else when making decisions as a director in the company. It sets a standard for the directors to act with integrity and prudence and to align their actions with the long-term success of the company and the sustainability of the company. This also means that the directors must avoid conflicts of interest in acting in their capacities as directors of the company. This includes things like avoiding making decisions on behalf of the company which would be personally beneficial to the director. Doing so would create a conflict of interest between the legitimate interests of the company and the individual director. Section 188 of the Act states that a director must not make decisions for the company which are contrary to the Articles of Association of the company. Under the provisions of the Companies Act, a company must have a set of Articles of Association. These articles will provide all provisions related to the management and administration of the company, the rights and obligations of the shareholders, and the objects of the company. Basically, the Articles of Association are like the constitution of a company. It lays down all the important details pertaining to how the company should be run. So what Section 188 does is that it states that a director must not go outside the scope of these Articles of Association when making decisions for the company. For example, a company's articles must outline the procedure for appointing directors to its board. If board members are added or removed without following these procedures, then these actions would be described as ultra vires and therefore would be in breach of Section 188. The Act in Section 189 requires a director to exercise due skill and care when making decisions. Further, the section requires that directors not act in a manner which is reckless and grossly negligent. This means that the directors must take the time to understand the information available to them and make informed decisions based on that information. Whether a director has acted with reasonable skill and care will be judged on an objective scale and not a subjective scale. What this means is the director's actions will be judged on whether a reasonable person in the shoes of the director would have acted in the same way or not. Now, in exercising the director's duty as per Section 189, the director may rely on certain documents and advice as provided for under Section 190. Section 190 allows the director to rely on reports, statements, and financial data and other information prepared and supplied, as well as on professional or expert advice given by an employee of the company, a professional advisor, or expert, or any other director in which the director may have authority. Section 190 subsection 2 goes on to provide that a director may rely on such documents or advice provided he is acting in good faith, makes proper inquiry in the event it is needed, and where such reliance is not unwarranted. So Section 190 allows a director to rely on certain documents and advice which are provided by the company in making decisions. Now, relying on these documents and advice in making decisions will satisfy the requirements of Section 189, which is that he must act with due care and skill. Now, Section 191 onwards in the Companies Act provides an obligation on the director to disclose any outside interest that he may have to the company. Section 192 states that once a director becomes aware of a transaction of the company in which he may have an interest, he must record the same in the interest register of the company and disclose this interest to the rest of the board. Now, this section is a very important section, and by satisfying this requirement, the director is also satisfying his obligation to act in good faith. Now, what the law is trying to do here is to ensure that a director of a company does not abuse his power to ensure that the company acts in a way which is in the benefit of another person or entity to which the director may have a personal connection. Doing so will mean that the director is not acting in the best interest of the company, and therefore he'll be violating his fiduciary responsibility. Another important duty imposed on the directors of a company is found in Section 219 of the Companies Act. Section 219 subsection 1 says that when a director believes that the company is unable to pay its debts, it shall call for a meeting of the board to discuss whether the company should begin winding up proceedings. Further, Section 219 subsection 2 says that if a director fails to do so, he may be liable for any loss the company may suffer as a result of continuing to do business in its current state. So what this section seeks to do is to create an obligation on the individual directors to immediately call for a meeting of the board when they find out that the company is in financial trouble, so that they can discuss the future of the company. Section 220 also imposes another obligation on the directors. It states that where the net assets of the company are less than half of the stated capital of the company, the board must within 20 days of coming to know of the fact call for an extraordinary general meeting of the shareholders, which must be held within 40 days of calling the meeting. At this meeting, the directors must provide a report of the financial position of the company and allow the shareholders an opportunity to ask questions regarding the same and the future management of the company. The purpose of this meeting is to ensure that the directors remain responsible to the shareholders with regard to the financial stability of the company. So if you're a director of a company here in Sri Lanka, it's probably wise for you to familiarize yourself with these duties that are imposed on a director of a company by the Companies Act number 7 of 2007. If you're unsure, it's probably a good idea to get professional legal assistance. Anyway, that's it for this episode. If you did enjoy this content, please do consider liking this video and subscribing to the channel. I'll see you in another episode. Take care. Bye.